After months and months of uncertainty, the MAT controversy has been put to rest. The Finance Ministry has accepted the recommendations of the expert SHAH committee, which will be music to the ears of foreign institutional investors. There will be no levy of the minimum alternate tax on capital gains made by foreign institutional investors and foreign portfolio investors, and that's also for pre-1st April 2015. However, there will be no such relief extended to foreign companies. This is not for FDI. CNBC TV 18's SHEREEN and MENAKA DOSHI spoke exclusively to the man of the moment, Justice SHAH, to understand his committee's recommendations. Here's that conversation.
Could you please take us through what were the comments or the objections or the criticisms, if any, raised by the CBDT, and in what manner did you incorporate your response to the final report that you submitted on the 25th of August, sir?
First, let me clarify. There was no criticism by the CBDT. The CBDT wanted to know, had some questions, had some concerns about the impact of the report on foreign companies having a permanent establishment or having a place of business in India. The issue which was referred to us was only in respect of FIIs or FPIs. Now, as far as foreign companies with permanent establishment or place of business is concerned, there was an earlier judgment in P14 and NICO in 1998, holding that such companies would be covered. In 2010, in Timken and Praxair, the authority, the Advanced Ruling Authority, held that this MAT provisions would not apply to FII or to a foreign company without a permanent establishment or a place of business. Now, this view was upset in Castleton by a single member of the Advanced Ruling Authority. Now, the issue before us was whether FIIs or FPIs were covered by MAT prior to the amendment of April 2015. Now, the issue was limited, and we submitted our report. And in our report, we categorically observed that we are not expressing any opinion about the foreign companies with permanent establishment or with place of business. Now, the CBDT felt that some of the observations might impact the cases of the foreign companies with PE or with place of business. So we made some small changes, and our recommendation remains the same, that the 115 JB prior to 1st April 2015 would not apply to FIIs. And the reason for that was, according to us, the 115 JB would apply to a company which is regulated by company law. Now, the company law would not cover a case of a company, foreign company, which doesn't have a place of business in India. If our view is that FIIs having no place of business are not covered by the regulatory regime of the company's law, and therefore naturally the MAT would not apply, because not only the machinery section but also the computer section would fail, because how you compute the income of a FII which is not required to file its accounts under the company's law. There is no guidance. As a result, the whole global income would be considered, and therefore we applied some of the judgments of Supreme Court, and we said that the FIIs are not covered by the 115 JB prior to the 1st April 2015. And there is no change in the report. The report remains the same. It is only by way of clarificatory nature, and this you will find it it is in chapter 5 and 6 of the report. That position has been clarified. So we have said.
So unfortunately, we've only just got the report, and we haven't had the opportunity to go through chapter 5 or 6. So for the benefit of our viewers,
you have to go through the report.
We will do that, sir, but if very quickly, for the benefit of our viewers, you can explain to us what were the changes incorporated on the basis of the reasoning you just gave us, sir.
No, we have suggested, there is another reason given by us for why the MAT is inapplicable to FIIs was that the FIIs are covered by a fixed tax regime, and the minimum tax cannot be more than the maximum. This is really happened in case of FIIs. And we considered that and we felt that it's a completely different tax regime, and obviously 115 JB is not attracted. We looked into the legislative history and the other relevant judgments, and this was our view. Now we have recommended that either CBDT should issue a circular to the effect that that FIIs would not be liable to pay MAT prior to 1/4/2015, or it can be done by a simple clarificatory amendment to 115 JB that FIIs were never covered by this law. This is our recommendation. Now it's a fact that in the meantime some 600 odd notices were sent. Some of the matters were adjudicated, and thereafter some are in writ court, some are in before some other authorities. So this is the issue, and then it can be easily clarified and it's for the government to take a call on this, how it could be, situation can be rectified. And really I won't be able to comment as to what course of action the government should adopt now, because it's for the Honorable Finance Minister to take a decision in that regard.
Justice Shah, I understand that you have clarified time and again that the scope of your committee was only to opine on the levy of MAT on FPIs, which is foreign portfolio investors. But and in my rapid reading of your report, I have come across a paragraph which says, therefore we find that the ratio in Castleton, that even foreign companies having no place of business or permanent establishment are also covered by Section 115 JB, is not the correct position of law. We therefore are of the view that MAT provisions cannot be applicable to FIIs and FPIs. Are you also of the opinion, even though it may not be part of what your committee scope was, are you also of the opinion that MAT cannot be levied on those foreign companies that do not have a permanent establishment in India?
All right, let me put the things in correct perspective.
Okay.
The reference was about the FPIs or FIIs.
Correct.
You are right. But see the judgments. The first, the NICO and P14, that said that the foreign companies are liable but those companies which were before the authority were companies with permanent establishment or place of business. In Timken, the court said that it will not apply to a foreign company without a place of business or without FPI. And in our reasoning, that flows from the Timken judgment. Or it is our interpretation also that if the foreign company or FII in the present case doesn't have a permanent establishment or place of business, because we recorded a specific finding that FIIs do not have a place of business in India within the meaning of the Companies Act, and therefore we in effect we said that the judgment in Timken is a correct law. So if a foreign company is not having a permanent establishment or a place of business, MAT will not be attracted. That's our judgment, that's our view. But since we were talking only about the FIIs, we gave our final conclusion about FII. But if that very ratio of that reasoning is to be applied then to a foreign company which is not having a permanent establishment or place of business in India, the effect will be the same. The Timken would prevail. That is what we said.
Okay, I understand that, Justice Shah. I know you said that it is not part of your mandate to suggest what the government process should be here on, but nonetheless, I'll ask you, the Finance Minister said that it would be most robust if there was an amendment to the Act in itself to clarify this situation, as opposed to just issuing a clarificatory circular, which may only be an interim provision right now to deal with the demand notices that have been sent out. In your opinion, that would be the best way to go about setting this process right?
I would not. I mean, if the Finance Minister has felt that the amendment to Section 115 JB would be a correct, a more desirable course of action, I'm sure that that must be so, because if a simple clarificatory amendment would put this issue to rest, I mean, completely, forever. I mean, otherwise, with circulars, I mean, we can't be certain, because there might be some some issues even after a circular has been issued by the CBDT.
That's a fair point, sir. I do want to ask you what your impression has been of this entire controversy that was born out of, as you have reiterated several times, just a single advanced ruling authority order. We've had previous AAR orders, as you have pointed out yourself, in Timken and Praxair, which have said that MAT would apply only to those foreign companies in India with a permanent establishment here. And then you had the Castleton matter, which was a foreign company, not even a foreign portfolio investor. You had just one AAR ruling. The AAR itself says that it does not set precedent, for other AAR orders, and yet this became precedent for an entire tax department to take action against foreign portfolio investors in the country. What is your impression of how this controversy came to rise?
Really, I mean, that's why it happened, because the issue kept alive because of the inconsistent judgments of the advanced ruling authority. The first judgment was not very clear, did not distinguish between a company with a permanent establishment or place of business and without a PE or place of business. The second judgment did that, and it was accepted by the department, and the department did not contest this position before in Castleton. But the Castleton, the authority had a different interpretation in his mind. So it felt that the 115 JB has an overriding effect, and it gave a different interpretation. So perhaps sometimes, I mean, I feel that the advanced ruling authority should be, I should not say this, but it should be more consistent. And if a different view has to be taken, I mean, such view should be taken with a lot of consideration, because in taxation, it's my view that the certainty is really a relevant factor, and if it gives to uncertainty, then it sends perhaps wrong signals to the investors abroad and even the investors within the country.
Justice, you've hit upon the irony in this matter, right? Because in the Castleton case, Revenue did not even argue in favor of levying MAT, and yet the judge presiding over the AAR decided that, MAT would apply to a foreign company that has a permanent establishment in India. Again, you've mentioned that the AAR should maybe take a broader view of the impact on foreign investment. Wouldn't you say that the tax department ought to have done so as well?
No,
I have relied on one AAR decision, sir.
No, I have not said that AAR should take a broader view. AAR is supposed to interpret the law. I'm only saying that there should be a consistent regime of taxation regime, or the consistent orders by the AAR. I mean, it's necessary for and again, you are not right when you say that the one ruling in Castleton has created this problem. It's not correct. Even if it is single ruling, still it has a binding, not binding effect, but it has some, at least a persuasive value. And the department, in view of this ruling, had, according to me, perhaps was compelled to issue notices, and which led to, this panic in the market and whatever, this led to the formation of the committee. So I wish that and surely, and it has been repeatedly stated by the present government, that they really want to, they wish to bring a more certainty in the tax regime in the country.
Justice Shah, okay, so just to get your view on that bit of the bindingness of an AAR decision, the perception was that an AAR decision is usually only binding on the person or the entity making the application and, the tax department. Do you believe that AAR decisions can also have precedent value?
No, I entirely agree with you that the AAR ruling would be ordinarily binding between the parties, but thereafter, there are some decisions of the Supreme Court that it has some persuasive value. Otherwise, there will be, with every authority, there will be different judgments. So it's necessary that there is more consistency in the AAR rulings, and really it should have some sort of a persuasive value, because it's also some sort of a guiding factor for those who want to invest in India. There is nothing wrong in that. though technically this is the ruling by the AR would bind the parties, not even the department. That's true, but it has a persuasive value.
Justice Shah, if I can ask you this, and I know you've gone at great length to explain that the terms of reference for your committee or your panel were to only look at the issue of FIIs and FPIs, sir. But in the course of your conversation with the Finance Ministry, with the government, and especially after you presented your report and then had consultations and then revisited your report, do you believe that given the investment climate, given the kind of inconsistent judgments that you yourself have pointed out, perhaps it would have been prudent to have expanded the scope and the terms of reference to include foreign companies as well, sir? Because that clearly was the expectation. We've got a lineup of tax experts joining us here on CNBC TV 18 who've expressed exactly that sentiment and that view.
No, it's for the government to take a decision in that regard. You see, a committee cannot say what type of references should be made to it.
Did you raise the issue, sir?
Really
Did you raise the issue at all?
No. I would not like to raise such issues. See, the committee is really concerned with the issues referred to it by the government. It's not within the scope of the. You may say that I'm a bit conservative about that, and I feel that the ordinarily committee should be giving answer to the reference made to the committee, and not ordinarily not going beyond it, unless it is really inevitable to go into the issues which are related to the main issue. So I feel that it's fine. I mean, let the government take a call. I mean, if any other issue is to be referred to the committee, surely then at that time the committee will definitely look into that.
Since you're speaking of other issues that will be taken up by the committee, when the committee was set up or instituted by the government, it had made it very clear that the immediate matter that this committee is going to look at is the issue of MAT on FIIs and FPIs, but other matters will also be sent to the SHAH panel. Has there been any indication of what next for you now, sir? What will be the next mandate?
No, frankly, there is no indication. But from the terms of reference, it appears that this committee's tenure is for 1 year, and it also reference speaks about the retrospectivity, etc. But frankly, I mean, there is no such conversation, and there is, at least I have no idea. I mean, what the government will do next. I mean, frankly, I won't be able to comment on that.
Justice Shah, you've made it clear in our conversation this evening and also in parts of your report that you do believe that if one was to extend the ratio of the AR decisions, then MAT would not apply on foreign companies that don't have a permanent establishment in India. That is something that the Finance Ministry...
Or both permanent establishment or place of business.
Or place of business, sorry. Sorry.
Or place of business in India.
The Finance Ministry has said, or seems to have indicated, that they will now leave that determination to the Supreme Court when the Castleton case is tried in the Supreme Court, is heard in the Supreme Court in the weeks to come. I'm asking not as the head of the committee whose mandate was limited to FPIs, but, as Justice Shah, do you believe that the reading of the Income Tax Act and that specific section should make it fairly clear, and therefore this is, a case that will go in favor of foreign companies, and that the Supreme Court will also find as you have found? I'm trying my luck here, but I'm trying it nonetheless.
No. I would not wish to comment on the larger issue, because it was not before us. The committee has not expressed any opinion on that, and I do not think it is proper on my part to express any opinion in my individual capacity. So since I dealt with the matter, so there are any number of experts, any number of lawyers in this country, and let them speak about the broader issues. I don't think I should comment on that.
But I do understand, sir, that you did get, you did invite several very detailed representations before determining or writing out this committee report. So you have an in-depth understanding of the situation. And therefore, I ask you in your personal capacity again, do you believe?
No,
do you believe that foreign companies with no place of business or permanent establishment in India
would not comment on that.
Pay MAT?
I would only say that this was also the argument of some of the lawyers who appeared before the committee, But as I said, that I do not wish to give any personal comment on this.
Menaka, we've also got Mr. Ketan Dalal joining us now, Senior Partner at PricewaterhouseCoopers. Mr. Dalal, we've got the man of the moment right here live with us on CNBC TV 18. Menaka and me have been shooting questions to him for the past 30 minutes or so. Would you have a question for Justice Shah?
No, well, I think whatever had to be asked, I think Menaka has already done that. The main question, of course, I had in mind also was regarding foreign companies, but I had the benefit of hearing Justice Shah for the last 10 minutes, and he has already said that he would not like to comment on it. Sorry?
Maybe if you try your luck, I said, sir, maybe if you try your luck, he might have a different answer.
No, I won't have a different answer.
I don't think I'm as skilled as Menaka in I don't think I'm as skilled as Menaka in asking questions, but of course one would hope. I think on a more serious note, I think the hope, of course, is that the government comes up with a circular that broad bases it to foreign companies, because at least in my humble view, the logic should apply to both. And I think the explanatory notes when MAT was introduced in 1996 and the two subsequent amendments make it expressly clear. In fact, one of the explanatory notes actually uses the word domestic company. So at least I think it was never supposed to apply to any foreign company. Unfortunately, the controversy triggered with MAT, and perhaps that's why the reference was made, was triggered with an FII, and therefore, because the notices in Bombay were issued to FIIs. But remember, Castleton is not an FII, in which the mandate had been broad-based. But I think, be that as it may, we are where we are. But I hope the government comes up with a circular that broad-bases it to all foreign companies and not just to FIIs.
Now, well, you raise a very important point, Mr. Dalal, and I want to try and take that to Justice Shah as well.
Menaka, I have to leave.
So, okay, I just want to put, if you can give me just a couple of more minutes, won't take more than 2 minutes. I have a quick question.
Okay.
As the head of the Law Commission, sir, would you say that, you know, especially this section, I mean, the poor drafting in this section, when you write in a levy of a minimum alternate tax and you don't make clear what kind of company it ought to apply to, that speaks very poorly of our ability to legislate in this country, isn't it, sir?
Now you are asking the same question in different manner. This is the third time. Now you are asking me as a chairman
I'm asking you about the section in itself, sir.
I ceased to be a chairman of the Law Commission from I think yesterday was my last day. So anyway, still my answer is the same, that I do not wish to comment upon this. Now, thank you, Panek.
All right, we'll leave it there, Justice Shah. Thank you very much for your time.